The Honorable Justice Jane Francis Abodo has been appointed principal judge, designated, because she's got to go through the processes and all of that. Look, this is one of the most educated judicial officers we have in our country, who seems dedicated to doing her job. My challenge has been, especially towards the end of her term as the Director of Public Prosecutions. There's been issues there, Irene. The Supreme Court on 31st January of this year delivered a ruling saying civilians should not be tried in military courts, and actually ordered that all pending cases before military courts should be transferred to civilian courts. Up to now, that has not happened. Each time I have raised that matter on the floor of Parliament, the Attorney General has said, well, it is the duty of the DPP to formally sanction files and charge people. And the Attorney General was saying, well, we cannot direct the DPP, even according to Article 120. She's meant to operate independently. So, in other words, throwing the ball in the court of the DPP. The outgoing DPP seems to also be throwing the ball elsewhere, saying, well, they're meant to carry out investigations and so on, but the duty to charge is yours. So I think that in that regard, she has failed these people who have been trying to seek justice, because now they belong nowhere. We have seen two recent rulings. Yasin Sechitoreko, also known as Machete, versus the state, and another, Anthony Agaba, also known as Bobby Young, versus the state. They've been trying to seek bail. Very recent rulings, and court said, no, we cannot grant you bail because you are not yet legally before us as the High Court. Your files have not been transferred from the military courts to the civilian courts. And so they remain in abeyance, and that would even mean they are being held in prison illegally, because the military court, which sent them there, is functus official, no longer has jurisdiction over them according to the ruling of the Supreme Court. The files are meant to be transferred to civilian courts. And now the civilian courts are saying, we cannot even hear your matter, we cannot grant you bail because you're not yet before us legally. And so these people are being denied their right to bail, their right to justice. They're still being held illegally, and everybody is blaming the other. So I think that the DPP should have moved fast on that issue. And that has been my concern, because now if you have left that work unfinished, you're now going to be head of the High Court. So which position are you going to take? Because now the High Court, which you're meant to head, is saying, we cannot attend to these people's bail hearings because they're not legally before us. The DPP is the one meant to sanction these files and all of that. And so you leave people in abeyance and stuck legally, which is a big problem, and it's something that I think needs to be addressed very quickly. Hopefully she can do that before she crosses over to the other side, because it is not right, it is not fair.
She's inheriting a position that High Court at other points.
The question of backlog is something we always put to all the appointed judicial officers that come before us as the appointments committee, whether it be High Court, whether it be principal judge, deputy chief justice, and so on and so forth. Their reasoning is, which to an extent, yes, is right, we need to beef up the judiciary. If you can have so many RDCs, and then you appoint deputy RDCs, and of recent, we added assistant deputy RDCs or that kind of thing, why don't you appoint more judges? Why don't you avail that to them so that they don't have an excuse? Because yes, there are some members of the public who will say, but well, even when the judicial officers are few, there are some judges who are not very active. They will report to work late, all the time they are away, or that kind of thing. But again, you've left them with an excuse that the judicial officers are few. And that's the call we have been making. Let's appoint more judicial officers. If you can keep appointing all these politicians and so on, you have I don't know how many presidential advisors, including those that don't even know what to advise the head of state about. You have so many RDCs, deputy RDCs, assistant RDCs, and many other offices that people are occupying without doing any work. Let's take justice to be a serious matter. And this is not a question of just the opposition, because even you ruling party fellows, you'll find yourselves before court and you'll need your matter to be disposed of quickly enough. So it's in the interest of all of us. So we always give them an excuse to say, but we don't have adequate judicial officers. Those that we have are trying their best, but they're not adequate. So we need to resolve that matter so that the question of backlog is taken care of.
The interaction was okay. The interaction was okay, yes. Yes, I can't say anymore because really.
Your success stories and the
No, I have not yet got the job. I have not yet got the job. I don't know the results from the committee. So let's wait for that. After we do that, then we can, because they might say no. Then I've already told you the task ahead of me. That would be really premature. No, I'm not. I'm still in that office. If I start talking about the success stories there, which means I've left it, it's a bit premature, okay? But I will definitely, you come once I get the job. You come and we shall spend a lot of time together. Thank you. Thank you.
Told the judges and judicial officers below him. So the absence of a principal judge definitely creates a very big gap in the management and governance of the judiciary at that level. So it is important that Parliament today has vetted the nominee for that office, and we think that the judiciary and the public should be eagerly waiting for that office to be filled, because as an administrative head, a principal judge handles many things. There are complaints that could be made to that office regarding individual judicial officers. There are issues that could be brought to the attention of the office holder, and each time the office has a vacancy, definitely undermines the running of the judiciary. Well, she has a very big task. Number one, the perennial complaints of case backlog. If you go to any judicial, any court around the country, the major complaint relates to case backlog. There are many cases that are unattended to in the courts. Some cases will last for about 15 years, 20 years. So you can imagine even the constitutional principle of justice delayed is justice denied is a principle that we are witnessing almost every day. The other day, lawyers in the greater Masaka area went on strike for the simple reason that the cases were not being heard. So the new principal judge has a duty to work obviously with the other leaders of the judiciary to ensure that they come up with the effective case backlog management processes. And they could take lessons from elsewhere. We have countries like India that have many litigants. How are they managing case backlog? So I think they could take studies across the world to try and understand how that is being managed. Number two, obviously, is the limited staff, the judicial officers. This may not be entirely her role, but definitely she has to work with other key stakeholders to ensure that the judiciary is well staffed. The case I have cited in Masaka, one of the challenges there is that there are few judicial officers, and that runs across the country and at different levels, both High Court, Court of Appeal, and Supreme Court. And so I think that is something we should address as a country, and that's one of the issues that the new principal judge should prioritize.
Awarding bail is discretionary to the judge.
Yes. Well, first of all, bail is a right, and the Constitutional Court has provided guidance on the issues related to bail. Number one, the Constitutional Court has said bail should not be denied mechanically. It's a grant of temporary freedom. It is one of the principles that underpins the concept of the presumption of innocence. So we are concerned, even as legal practitioners, we are concerned at the way some of the judicial officers are handling matters related to bail application. First of all, an application for bail should be the simplest of applications. But you find instances where judicial officers are adjourning bail applications. In principles of bail are very simple. You are not going to restate the law. From the Constitution, the law is very clear on the grounds and other laws. But we are witnessing incidents where, for example, that discretion is being exercised in a manner that is very disturbing to maintain decorum of the courts. So I want to appeal as a legal practitioner myself to the Chief Justice, the Deputy Chief Justice, and now the Principal Judge, to ensure that bail guidelines are streamlined and structured in such a manner that the constitutional presumption of innocence is maintained and preserved by those bail guidelines and regulations.